Welcome everyone, and thank you so much for joining us here today in the first of a four-part series to do with working with international and cross-border clients. I'm thrilled to be joined by Marina Hernandez, an ambassador to the GFP, the Global Financial Planning Institute. My name is Ashley Murphy. I'm the co-founder and president, and we've put this wonderful series together for you that I hope you will be part of. The GFP Institute, we got started mid last year. Shortly, we'll be commencing our third trimester of the masterclass beginning June 3rd. And we've been very lucky to get a lot of positive attention, including from Michael Kitzis, from Bob Veris, and Inside Information, and various other sources. We do have some journalists joining us for this presentation series as well, both in the US and in Australia. So I'm very, very excited about their attendance here. So the Global Financial Planning Institute, very quickly, what's this organization all about? Founded mid last year to provide education, community tools, resources, and ongoing research for fiduciary advisors and affiliated professionals worldwide who work with clients whose financial lives cross borders. So it's quite a mouthful, but I think that should be pretty clear to you. If you're working with clients whose financial affairs cross borders, then this is really the organization for you. I was prompted to get this started given my own experience when I moved to the US in 2005, and I went looking for a financial advisor or an organization or a book or a website that dealt with these issues, and what I found was absolutely nothing. And then upon becoming an advisor a couple of years after moving, I thought surely there'd be something in the advisor community. There were the occasional sub-chapter meetings and conversations here and there, but nothing that existed to really put advisors on the same page, educate them as to what the issues actually are, and have elevated conversations and be able to provide the best advice to their clients. So as I mentioned, this is the first in a four-part webinar series. Here are the other topics that we'll be presenting on in 2-week intervals. Next, coming up towards the end of the month, we'll be building an international practice, business models and compliance. I know that that's something that's often on people's minds, is how to work with clients profitably or how to choose a niche in the first place. May 11th will be investment considerations for the American abroad. We had a very robust discussion with one of our guest speakers a few weeks ago in the masterclass about the different approach he and his firm take towards investing on behalf of his international and cross-border clients. Lastly, Marina will be joining me again on May 25th for treaties and the definitions of residency. We'll be getting into a little bit of detail talking about the 3 definitions of residency being legal, tax, and estate. Unknown to most advisors who aren't working with this particular population is that there are in fact 3 different definitions. So all sessions will be at this time. I have to say that selfishly because of me. I'm here in Australia right now, Brisbane, Australia, and it's just gone 6 a.m. So there was something about doing it a few hours earlier that just wasn't especially appealing. Okay, so let me briefly introduce this morning's presentation. We're going to be quickly covering off on the differences between cross-border and domestic planning, the phases of the expat move and how the advice changes over time. Marina's going to be getting into detail about the bear traps and pitfalls that face international and cross-border clients and the advisors inadvertently that serve these kinds of clients that might not know about these bear traps, challenges in working with the expats, differences in fact-finding and presentation. I would put it to you, and indeed will put it to you, that commencing right from your initial fact-find with a client, that's when you begin to experience some of these differences in this particular client population. Next, we'll be going into something we wrote a presentation on, and a white paper is in development, how the US financial system changes the advice provided. What are the particular pros and cons about being in the US and the situation that faces that international or cross-border client where they may choose to do certain things in the US or outside of the US. And lastly, we'll just provide a few minutes of detail on this masterclass in US inbound, outbound, international financial planning. So with that, let's get into it. All right. So cross-border versus domestic planning, what are the differences here? Well, cross-border is a very particular kind of financial planning. We'll get into that definition at another time, but really domestic planning, we might not have thought of this when we undertake our CFP studies or PFS studies or whatever kind of advanced financial planning designation you have. It was only dealing with the issues of one country. There, to my knowledge, there's a single reference to international and cross-border issues, and that's on the estate planning side of the CFP curriculum. But this is incredible given the magnitude of this particular niche market. We're talking about a group where there are more than 30 million individuals born abroad living in the US. Another almost 9 million individuals, Americans, abroad in over 180 countries, and tens of millions of other individuals that are coming through on so-called non-immigrant visas. These are the folks that are in the US, H-1B visas, L3 visas. These are folks that by definition have a higher education, higher average income, and potentially, although it depends on their age, of course, but higher net worth than a comparable domestic client. And I say that some people might get their back up with the words that I just said, but it's really not contentious because those visas require certain skills, education, and experience to qualify in the first place. So traditional planning ignores the needs of the cross-border financial client. And what we see time and again is simply, and I completely understand this, and indeed this was one of the major motivations for getting the GFP organization started in the first place, was often an expat client will be in the practice of a domestic planner. That domestic planner doesn't want to turn away what could be a fine kind of client for the firm, and surely there aren't too many complications. And so the advisor accepts that client, not knowing what they're getting themselves into, but then they have difficulty really locating those answers, locating the service providers that would be able to help that client. And so that's why I got this organization started. So inbound, outbound, and cross-border planning. Let's divide up these categories and go into a bit more detail. So inbound planning is really to do with folks moving into the US. There'll be no extra points awarded for figuring that out. So that's thinking of what are the issues someone is going to be facing when they move into the US. Conversely, outbound planning is exactly what you're thinking. It's planning for that move out of country, tying up the loose ends and making sure that that client is not going to be disadvantaged in any way in their move overseas, and is going to be aware of what they're in for with the US side of things, which Marina will be talking a little bit more about shortly. Cross-border planning, as I mentioned, there's a specific definition that applies to cross-border planning. Really, that is when you're talking about the advice provided to someone in both countries. It's not simply inbound, outbound, where you might say, gosh, I don't know the financial planning landscape in country X, Y, or Z that client is moving to. Cross-border planning is when you say, I actually do have advanced training in that other country, and I can talk to both sides of the issues that this client is facing. And that's an expertise that Marina here has. Marina is an expert in the Swiss side of financial planning and the US, obviously, and I'm an expert on the Australian side and the US side. So it's really the most specialized form of financial planning, because it's not only are you a domestic expert, but then you're an expert in a different country altogether. Put this together, and we'll say inbound, outbound, plus cross-border. We'll use that term global financial planning, and hence how we came to call this the GFP Institute. So phases of the expat move, really the type of advice provided to the client is going to differ depending on the stage of the move. So the pre-move is going to be dealing with immigration. And I have a great story just from Monday of this week. An old college friend of mine, he emailed, he said, hey, Ash, My friend is moving from Australia to the US. He's got a Delaware C Corp. Hey, just help him out and give him the quick 5-minute spiel on what he needs to know. And Marina, why does that produce a smile on your face when you hear me say that? Well, I wrote to my friend's friend and I said, hey, thank you for reaching out. I'd love to assist, but honestly, it looks like you're looking for cross-border tax advice. Here's a referral of a firm that I can recommend. And I wrote back to my friend and I said, Mark, here's the situation. Actually, your friend really should have begun thinking about this. Ideally, it's not possible now, and we'll make do with his situation should we commence to an engagement. But really, that advice should have commenced 5 years beforehand, more than 5 years beforehand, because the US has a 5-year look back, not unlike with other forms of domestic planning where there's a 5-year look back for gifts. And that's because becoming a US tax resident is going to mean that the US will look at those foreign assets at their original basis, meaning before that individual ever entered the US financial system, the US is going to look into whatever the original cost basis was of those assets and tax based on that. Planning that had commenced 5 years beforehand would be able to deal with that and would be able to minimize that particular tax obligation. So other pre-move issues would be banking and cash management. Of course, if an individual is going to be moving to the US, it's important to realize they don't have a credit score. That's something you're going to need to work with them to help them get set up as soon as possible. Tax and estate planning issues have come into it as well, and I just alluded to that a minute ago with the worldwide tax system and the inherited basis that the US applies. Family issues as well, education standards, are the kids going to be able to slot in to the appropriate grade at school. Next phase in the expat move would be the acclimation phase, so getting used to the altitude. Well, welcome to the United States, where we're the only developed country to practice citizenship-based taxation. There is Eritrea. Recently, China has begun to implement a little bit of this, but by virtue of being a US citizen, no matter where you are in the world, I should say, not just a US citizen, a permanent resident, or a US tax resident at all, no matter where you are in the world, Uncle Sam wants to assess and determine whether you owe tax on whatever income or transaction or situation you might find yourself in. Does it always mean double taxation? No, there are many double tax treaties that we go into in a lot of detail in the course, but it is certainly an adjustment that people need to be aware of. Real estate decisions people need to consider in that first phase. Of course, many of our clients have a strong desire to own property. Whether that makes sense for them or not is another question. 401k savings, all of us on this phone call have probably seen this, where individuals that are newly arrived in the US, they might look at a 401k, they don't know how long they're going to be in the country for, and they say, oh gosh, this seems like a lousy set of investment choices. I don't know if I can even get my money out of this program. I'm not going to contribute at all. The decision to contribute really is dependent on a country by country basis, I would say, as to where someone's moving back to, and even a client by client basis, how long they're going to be in the US. But I am certainly a big encourager of participating in those plans for the Aussie expat clients I work with. Next would be stock options and other equity-based compensation, not necessarily so common in other parts of the world. And even if it is, the breadth and variety of equity compensation is different here in the United States. Next phase, global financial integration. So we're talking about long-term immigration planning, the decision to move from that visa and get on the treadmill of possibly becoming a US citizen. So first step there would be obtaining a green card. Well, gosh, are there financial implications of that? Of course, certainly not just the cost of the green card itself. That's a fairly minor thing. But the big one we need to watch out for would be the exit tax. If someone stays in the US for 8 or 15 years and fails one of 3 tests, they'll find themselves a covered expat and subject to a US exit tax, a very unpleasant thing if someone is unaware of that bear trap that they're walking into. Marina will be talking more about that in a little while. Coordination and allocation of worldwide assets. Of course, I am a believer, not everyone is, but I'm a believer that you really would do, a client would do best to locate their assets in their country of domicile. Domicile, what's that? Where they see themselves long term. It's, in my view, it's going to add administrative hassle. It's going to introduce foreign exchange risk if we've got assets here, there, and everywhere. So where possible, let's try and integrate and consolidate as much as we can. Next would be tax planning, and that's kind of goes with what I was just saying a minute ago about the integration of assets. And lastly here, this is really where you begin to see the inbound client, inbound to the US, the permanent mover, and I'll talk about the different types of expat clients in just a moment. You really begin to see a confluence of or a consolidation of factors. So over time, that expat client, if they've been in the US for a number of years, they've consolidated their accounts, there isn't much going on anymore. Maybe there's an odd inheritance here or there, or a retirement account that they're now able to access by virtue of the client's attained age. By this point, they're really beginning to be quite similar to domestic clients. And so we're looking at many of the same retirement issues, but with a sprinkling of those expat issues thrown in there as well. I should mention credit goes for this graphic to Andrew Fisher, the author of the Cross-Border Family Wealth Guide. Expat residency intention. So this is where I would broadly identify three kinds of expats, and their planning will differ depending on the type you're talking about here. So we have our temporary movers. Who are they? They are mostly folks for our audience here today. These are really going to be the Americans moving abroad for a period of time. I would say their financial center of gravity is not going to move from the US because by definition, they're only temporary movers. They're going somewhere for a couple of years, maybe as long as 6 years. Doesn't sound so temporary, but would someone be well advised to make permanent, lifelong financial decisions by contributing to retirement accounts, by buying real estate and so forth, and entangling and meshing themselves in a foreign financial situation if they were only there for such a period of time? Probably not. And we see this obviously in reverse with other folks coming in on various kinds of visas into the US for a number of years. I think that hourly financial advice is really well suited for the temporary movers. They just need help in that the pre-move and the acclimation phase, but they're not going to so commonly get into those integration and financial independence phases. Next, we have our domicile uncertain movers. This was me. Back in 2005, I took 6 months off, as Aussies seem to be genetically programmed to do, went traveling around the world, landed in the US, and I said, this is fantastic. I'm loving it here. Did I have any firm plans to stay? No. Did I have any firm plans to leave? No. I was just waiting to see where life took me. And that is the case, I would say, for the majority of folks out there, Americans abroad, indeed, and individuals in the US. They're really just going to see what happens. Do they meet Mr. and Mrs. Right? Do they get that promotion? Do things fall together for them? In this case, the emphasis is really on flexibility. So we want to make sure until that certainty is there, until that promotion or meeting that person happens for them, then we want to make sure that we minimize the cost of any particular decision that they make and maximize flexibility. Lastly, we have our permanent movers. Pretty rare in my experience, Marina, perhaps you've had a different experience, but pretty rare in my experience that folks just say, right, we're done with whatever country we've moved from. It's US or bust. Perhaps I should say that's coming from Australia, the only country in the world where you have more Americans moving here than the other way around. That's somewhat idiosyncratic to perhaps Australia, but it's pretty rare that I see that. But the permanent movers are great because they really go through that 4-phase process we saw on the previous slide in an accelerated manner. And that's because they know they're moving. They want to get on with that consolidation as soon as possible. Challenges of working with expats. So This is just a brief introduction here, and I'm going to flip the way that this slide is written just to make it make a little bit more sense. So we all take it for granted living in the US that we understand the insurance, the healthcare, the legal system, the tax system, the retirement system. Well, it's a completely different world out there when you move to a different country. I happened at the beginning of this year, I moved back to Australia where I'm coming to you right now. I moved back here and boy, was I in for a shock with, it's been 16 years since I last lived here. And it's a whole new world with every one of these issues. So you can imagine the experience of someone moving to the US. What on earth is a 401k and why is it called a 401k? I'm going to hold questions to the end. I saw that little banner there at the top too just popped up, but to keep moving here for the benefit of the recording, I'll save those to later. So clients often have a high need for planning due to higher incomes and net worth. Absolutely. As I said earlier, that's a condition of many of these visas, and by and large, you'll find a higher concentration of these clients in that situation. Cross-border rules are ambiguous and constantly changing. How could that possibly be? How could it be that they're ambiguous? Well, here's why. When the lawmakers get together and they write laws, they don't consult with Switzerland. They don't consult with Australia and say, does this integrate with your definition of what a retirement account is? No, they do not. And so what you end up with is this hodgepodge, this quilt of different plans, different account types that may not match in definition from one country to the next. And so we need to consult with tax attorneys, at CPAs, look at private letter rulings, all sorts of things to figure out what the proper treatment is in a given situation. Furthermore, it's made all the more complicated by the fact that these bilateral agreements, these various treaties that exist, are not uniform, meaning they were written at various points in time when certain account types existed or certain estate taxes existed in one country or another, and may no longer exist, or indeed may no longer even be enforced in the case of the US-Australia estate tax treaty. So there's significant variation. I'm actually doing a webinar later today for my target market on claiming Social Security abroad, and found that, interestingly, and Marina knows this, Marina was someone that shared this fact with me, that the US reserves the right to tax Social Security everywhere else in the world except Italy. Italy, somehow in their totalization agreement, they struck a different deal, and the Italians somehow are able to tax Social Security there. So that's just an example of one of these differences. I'll be handing over to Marina very shortly, but before I do that, some more issues here to do with special cross-border needs. We're looking obviously at all those issues on the previous slide. Immigration and residency. This is why it's a specialized field. By virtue of being a tri-citizen, I didn't know anything about visas or the immigration process or how that worked because I never had to. But by virtue of working with this client base, I've had to learn about these different types of visas, what it means for spouses and children to work, what it means in terms of their uncertainty and their planning horizon. So that's a whole nother specialized field that we've had to get into and learn about to work with these clients properly and professionally. Investments, that's a can of worms right there. Given something Marina will be talking about in a minute. Passive foreign investment corporations, real estate management. We cover that in lesson 8 of the masterclass. Foreign exchange and international accounting. I was just saying to someone yesterday, foreign exchange is one of those areas that I would put it to you is going to be regulated at some point in the future. Why do I say that? This is just one person's opinion here. Well, we all know that mutual fund share classes are one of the hot button issues that regulators will focus on, right? If your client should have been in an institutional level share class because they were eligible by virtue of your relationship with your custodian, and you've got them in a more expensive share class, then you're going to get dinged because that was clearly not attentive of you to allow them to pay more money than that. Well, the same thing with foreign exchange. It's people don't pay any attention to foreign exchange. It's boring. It's what could there possibly be to know about foreign exchange? Well, it just so happens that there are wholesale and institutional foreign exchange providers who will provide a spread, which is essentially the cost of foreign exchange, 1/6 of that, of the best retail alternative. And indeed, that is what we have negotiated for GFP Institute members, is 1/6 of the best. So that is literally leaving money on the table if your client is using something like TransferWise or OFX or whatever. So there's numerous challenges and pitfalls that can lead to severe negative consequences. I will leave it to Marina. I'll swap over and she will begin talking about these other issues and pitfalls and bear traps.
Thank you, Ashley. Hello, everybody. It's great to be here with all of you. Thank you for joining us today. We see that we have some questions. We're answering the questions at the end, right, Ashley? I just go on with the presentation right now?
Yes. Yeah.
Okay, perfect. So we're going to start talking about other issues that are also very important. And really, it all boils down on the US side of the international and global clients on the main issue of citizenship-based taxation, which is something that Ashley alluded to early on, that leads to a lot of known unknowns and also unknown unknowns. One of the things that I see all the time is people that really don't have a most basic understanding of what issues even they need to consider. That's why Ashley got that message from a friend saying, can you give me the 5-minute explanation summary of what you need to do when you're a foreigner with a Delaware corporation moving to the United States? There's just so many. That is a question that reveals a lot of unknown unknowns. And so what we're trying to do here through this presentation is to clarify some of those and also to also give you information on the known unknowns. And so because when foreign nationals move to the United States, they bring with them all of their history. They're bringing assets from abroad. When Americans move outside of the United States, they also take all their history with them, and they still have to carry the citizenship-based taxation. And so what are the issues that come from that? How is the foreign country, whether that foreign country is the US or the country where the American citizen moved to, going to look at those retirement accounts? How is the US going to tax those retirement accounts of a different country? In addition to the citizenship-based taxation that is unique for the United States and applies to Americans who leave and green card holders who leave, and the number of green card holders that are shocked to find out that when they leave the United States, they continue to be taxed as if they were citizens and residents of the US. They all think for some reason that tax treaty exempts them from it, and it tends to be a very common shock. On the other hand, when you have foreign nationals moving into the US, they only have to worry about something that may be unique, which is the worldwide taxation that the United States have. There are some countries that only tax their residents on a territorial matter. And so they do not have to worry about assets held outside of the country of residence or income from outside the country of residence, because those are not considered. But the US has the double whammy of being citizenship-based taxation on worldwide income and assets taxation. And that's why it becomes so complicated. So how will the US tax those retirement accounts? And there's all kinds of different answers, and we cannot go into all that type of details right now. How is equity compensation going to be taxed? Equity compensation, when you have executives that move from one country to another under an opportunity for an expat assignment, a foreign assignment, they will carry compensation that started to vest in a different country. So there's a history that is always trailing. And so you will see that they will continue to be taxed on some of the compensation. Some countries will tax them in an accelerated manner when they leave, like Singapore, for example, would do that. So all of those are different depending on the country to which you're moving to or the country that you're moving away from. And those are other additional complexities that you need to be aware when you're working with international clients. No planner can be an expert on everything, and that is really the biggest conclusion. So when you're working on the international area with global clients, you need to understand that there's a lot more of research that you will have to do, and it's really important to develop your own network of other professionals who are going to have the expertise in the areas where unavoidably you're not going to have the In the US, you can find a lot of information on databases that are public. It is fantastic. As somebody who is a cross-border planner and worked really hard to gain expertise on the Swiss side, I can tell you it's a lot harder to get that information from Switzerland, for example. It's not available publicly as it is in the US. And with many countries, I expect that it will be a similar situation. I don't know, Ashley, how it is in Australia. Australia is probably more public information friendly with that kind of thing, with case law,
Yeah,
tax
very.
treaties, agreements. But in Europe, it tends to be quite obscure. Latin America, very obscure. Some countries in Asia, the same thing. It's difficult to even know where to find the reliable information about what the law is and what are the different considerations and issues that you have to take into account with your clients. Can we move to the next slide, please? All right, so failure to understand citizenship-based taxation, that is the mother of all the bear traps. And with that, there's the education piece of a foreign national moving to the US, like Ashley did, thinking he was going to be a few months here. I did the same thing, by the way. So, but Ashley was already a US citizen before he moved. I was not. I became one. So I had some time to evaluate whether I really wanted to subject myself to citizenship-based taxation by the US for the rest of my life. And for me, it was a resound yes. So I have no regrets of being a US citizen. But this applies not just to US citizens, it applies to legal permanent residents, which are green card holders, and the citizenship-based taxation, not the citizenship taxation, but the worldwide taxation piece of it applies to anybody who is considered a tax resident of the United States. You also have the substantial presence test as the third test under which you can fall under US tax residency. So it's the citizenship-based taxation that follows US citizens and green card holders who maintain the green card when they leave the United States. And for everybody while in the United States, citizens, green card holders, and residents under the substantial presence test, which is people that might not even have immigration status in the US. They can be tourists that stay for very long, for longer than they realize and they meet this test. That is the worldwide taxation. That is one of the biggest bear traps. The next slide, thanks. All right, so in addition to citizenship-based taxation, is, as we mentioned, the fact that is the worldwide income and the worldwide assets reporting that is a very big bear trap. With respect to worldwide assets reporting, there's two main systems of reporting that are required, which is the FBAR, which has been in place since 1971. It is more like an anti-money laundering rule. That any US resident that holds foreign financial accounts that have a value of more than $10,000 need to report them. This is something that wasn't very, they didn't have a lot of compliance until 2008, when there was the UBS scandal in the US that initiated all the Department of Justice inquiries into that, and eventually led to FATCA. There was a legislation that was passed in 2010 that now makes a requirement into reporting for foreign financial institutions, their US persons who hold foreign accounts, if the accounts meet certain requirements, and for US persons, US tax individuals, report the foreign accounts which they hold, and they have higher thresholds of reporting. But the penalties are pretty significant for making mistakes or for not reporting the accounts properly. So there's severe consequences about not being aware about these traps. Passive foreign investment companies, that is a very big issue that we see. I know that there's a lot of my tax colleagues here and they're probably going, passive foreign investment companies apply to foreign companies, like I said, so companies who are not US domestic, that meet the definition of a passive foreign investment company. And that typically is investment funds. Foreign investment funds typically fall into this category, but not just necessarily investment funds. There are other type of companies that can be set up by clients that fall in this category. For example, a foreign entity that holds real estate that would either be owned directly by a foreign national who moves to the US, or a US citizen who moves abroad and purchases rental property in a foreign country through a foreign entity. The reporting is quite complex, and the taxation can be quite punitive. And finally, the HART Act, and I like to refer more to it as the expatriation issues, and that's because that's what we deal with on the tax world. I'm very tax centric because I started working with international clients in tax and then expanded it to financial planning and wealth management later on. And so, with respect to the expatriation issues, is many Americans, when they become aware of the burden that continue to be subject to citizenship-based taxations imposes on them when they no longer live in the U.S. And the same thing happens with green card holders and meets the requirements to be considered a long-term permanent resident, the 8 out of 15-year test that if in the masterclass gets taught in more detail, is that they're bending on the situation of the person who wants to renounce citizenship or give up their green card to avoid having to deal with these issues, is that there might be an exit tax that applies and a cover gift tax that could apply to their US citizen heirs. And so there's really important considerations to take into account, and it's a really important issue that a lot of people are not aware of.
But Marina, just can you say
Yes.
that again? I'm not sure everyone heard that. You mentioned the HART Act. If one is to fail one of these three tests, not only are they subject to an exit tax, did you also say the heirs could be impacted in some way or another?
Yes, they're U.S. citizen. If they have U.S. citizen heirs, there's a cover gift that applies to anything that they inherit from the cover expatriate.
Mm.
And so it's and it, even if those assets were acquired by the cover expatriate after expatriation, I do not know to what extent those rules are being enforced. It doesn't seem like they are being enforced currently, but they do exist in law. So there's really clearly a risk there. Failure to appreciate the foreign taxation of US accounts. So this is something that is very common, and you can see it both for Americans moving to foreign countries and also foreign nationals moving to the US. For foreign nationals moving to the US, there can be all kinds of tax advantage accounts. We have people from the UK, I believe, attending the seminar. So you have ISAs, for example. There are all kinds of Canadian accounts that have tax advantages in Canada. You have the similar thing in every country. The United States will not automatically recognize that treatment. Most likely, you need to assume that it won't. And the reverse can also happen. If a U.S. expat that has 529 accounts where they or Coverdell savings accounts because they've been saving for the children college education, or some type of Roth, sometimes countries do not recognize Roth IRAs, even though they are retirement accounts for U.S. purposes. Some other countries will not recognize that. Those countries will be taxed as they don't have any protection by the foreign country or by the U.S., by the foreign national in the U.S. holding those accounts, or even a U.S. citizen who was temporarily abroad and acquired one of those accounts and then later returned to the U.S. Estate planning issues. Estate planning is really significant issue. You have very commonly when you're working with international clients, couples where not both spouses might be U.S. citizens. And so you have a spouse that is a U.S. citizen and another one that isn't. And there's no unlimited marital deduction from the U.S. citizen spouse to from the U.S. citizen spouse to the non-U.S. citizen spouse. And that is something that needs to be planned for, particularly in the event of the U.S. citizen spouse passing away before the non-citizen spouse. I think in point B, we're talking about non-resident aliens and estate planning, Ashley, in the next. Yes. And for non-resident aliens and this situation, you might have it when you have a foreign national coming to the U.S. temporarily on an assignment, or a foreign national that is coming to the U.S. on the type of visas where the days of physical presence in the U.S. don't count towards tax residency. You might have the issue that they are subject to estate tax without the proper exemption. Right now we have an 11.4 million exemption, I believe, although that might change in the near future. When there's the owner of the U.S. Citus property is a non-resident alien, Without a tax treaty that might remedy this to some extent, the exemption is only $60,000 and then state tax applies. And that can be really shocking to a lot of people because there's very little awareness of this risk. The ownership of businesses, well, whether within foreign trust or without foreign trust, can be really complex. Foreign trusts are add another layer of issues too. Um, when you have, there's two ways in which a U.S. trust can become a foreign trust, or when somebody can move into the U.S. with foreign trust interest. But the important consideration with regards to foreign trust, and then I speak separately about ownership of foreign businesses within or without foreign trusts, is that the U.S. has rules that makes it very difficult to defer income through foreign trusts. And they're purposefully put in there to make it very expensive to defer income through foreign trust. And also they want to know what's on this trust. So there's a lot of reporting that has to be done. And the penalties for the failure to report are pretty significant. We could be between 25 and 35% of the value of the unreported income or the unreported asset. And they had been enforcing those penalties, or they had been applying those penalties really seriously lately, starting in 2019, and it's been getting more and more prevalent, the application of those penalties. We have many US citizens that have US trusts, and then they move abroad, and some of the members of the family, what we were saying earlier, might not be US citizens or US persons, and then they might have a non-resident alien that is a trustee of the foreign trust, and they don't realize that makes that they is a trustee of the U.S. trust, and they do not realize that makes the U.S. trust a foreign trust. And that creates all kinds of complications as a result of that. Individual disability and group life insurance products that don't pay overseas. So again, not being aware that obtaining insurance and continue to be able to pay for the premiums does not necessarily mean that you're still being covered. Every insurance policy has considerations under which the contracts are valid, and many times residing in a specific country, because insurance is a very regulated industry, not just us as financial advisors, but insurance is also very regulated. And so there are restrictions to protect the residents of every country of who can write policies or not. And many times those policies become void by moving to another country. And so that requires the education piece that Ashley was alluding earlier of becoming aware of what the different type of insurance policies are in the US, what is automatic and what isn't for people moving into the US, and for Americans leaving the US to really find out if their policies is going to continue to be valid, or they need to switch to some type of other insurance that will provide coverage while they're abroad. The wrong type of account we already touched when we're talking about Roth IRAs, 529s, cash-valued insurance products that might not be recognized by the foreign country for Americans moving overseas, or by the US for similar type of investment accounts that the foreign national brings into the US. So you don't realize all the special tax benefits, but you have to suffer all the restrictions, because typically those accounts come with restrictions in exchange for the tax benefits. So you get the worst of both worlds. You don't get the tax benefits, but you get to keep all the restrictions. So it could really be an issue that needs to be taken into account and to be planned for. The fact-finding process is therefore a lot more encompassing and needs to be a lot more detailed when you are working with international families. Yes, understanding what is the legal residency status in the US or the foreign country. I get questions all the time, like, I have this client that has this asset or has this income, what is the treatment? And then I start asking questions about, well, they live in China. Well, are they a US citizen? I don't know. Are they a record holder? I don't know. Okay, those are important questions, because depending on whether they're one or the other, the answer is different. The reverse also happens with foreign nationals living in the US. Are they US citizens? Are they green card holders? Because their residency status impacts the consequences on their income and their assets and their treatment in the US and abroad. What day did they depart on arrive? That matters for the determination of some timelines that you need to take and keep track of to see whether a person goes from residency exempt status, so they're considered as non-resident. Did they stay longer than their type of visa allows for the exemption? Now, what do? We need to plan for the change of tax residency status. Or if they have green card holders, are they approaching the anniversary of that 8th year where they really need to make decisions because now they're going to be covered by the HART Act, and they have to really consider what the implications are for long term for their life once they become covered under the section of the Internal Revenue Code. And so if they stay in the United States, for how long? I'm going to give you a very common example that I see from people, and these are things that at the beginning they surprised me, and then they do not surprise me anymore. A lot of green card holders leave the United States and believe that if they put the green card in a drawer on the bedside table and never look at it again, they're magically non-U.S. tax residents or anymore. And that green card may not be valid for immigration purposes, but it still counts towards their tax status. So people operate on a lot of wrong assumptions, and your clients are going to be operating from a lot of wrong assumptions. And the value that we give as advisors is understanding and assuming that they are going to be operating from assumptions. We need to know what those assumptions are so that we can help us, because there are a lot of things they're not going to tell us that is going to impact their situation. They don't tell us because they are worried that it's going to be a problem, and it might not be a problem at all. And they create the problem by not telling us, which is why it's really important to have a really detailed and in-depth fact-finding process when you're working with international clients. Also, what are the plans? What are their intentions with respect to domicile? Because in everything that you do in life, typically you have options, and those options have different type of consequences. And whether option A or B is better, that cannot be decided without the context of everything else that matters to the clients. It's really for that particular client, what is the right option to make, the right option to choose, what is the right direction to take, and what are the different timelines that we have to keep into account once we made the recommendation to the client to course correct if the facts change, the circumstances change, or if the laws change, which are constantly changing also. Can we go to the next slide, please, Ashley? Great. Work history. Work histories has important implications for the taxation and transfer of assets because it gives you information about what tax deferred accounts they might be holding that you need to be aware of, and what income and other assets they might be holding in the foreign country. And so they have issues of executive compensation that started to be accrued in a foreign country and continues to accrue and invest when they move to the US. So there are trailing effects from the foreign country. There's issues of cost basis. An issue that I'm going to mention because it's overlooked a lot, a non-resident alien, so somebody who has no U.S. status whatsoever, who moves into the U.S. for the first time and has assets that they acquire in a tax preferential manner abroad, has zero cost basis in those assets for U.S. purposes. So I see this mistake made all the time, and I'm going to give you an example. Somebody who called me a couple of weeks ago, and they had a retirement account in Switzerland, and they wanted to bring the money to the US, and they wanted to know what the tax consequences were. And of course, the answer is it depends. And in this particular case, this is an account that this person had contributed before he had ever set foot in their lives in the United States. And those contributions were all tax deductible in Switzerland when they were made. That person has zero cost basis on that account. And taking the distribution and bringing the money to the US means they has to pay income tax on the entire distribution, whether in the foreign country, in Switzerland, it is taxed at a preferential rate. There's no such benefit. There's no cost basis recognition. Now, had that person been working with an advisor that was aware of this cost basis issue, they would have planned differently to maybe do the transfer from that account before becoming a U.S. resident, so that it would be in an after-tax account in the foreign country and wouldn't have to pay any U.S. tax at all on that distribution. About potentially a cost of more than $300,000 for this person. A mistake like that can cost hundreds of thousands, and depending on the size of the asset, on the type of asset that we're talking about, sometimes millions. Sometimes it's just a few hundred. That's easy, but you really doing the planning for pre-immigration is very significant. It's really can be very significant, and we can provide very significant value to clients. The next slide, Ashley. All right, asset allocation history. Where and when were assets acquired, and what are the implications for financial planning? Compliance is something that you need to understand. We need to understand as advisors, because this can be complex and because the consequences of errors in compliance can be so severe. Identifying where there could be PFIC issues, and making asset transfer recommendation. And this is the example I just spoke about, the timing of doing the asset transfer. That timing can make it can have an enormous difference in the result for the client. And so if you are working by yourself with those type of issues, it's very difficult that you're going to be aware of all of them. So having a network of experts and a database that you can access becomes really important to help you identify where those risks and those opportunities are, because for every risk, there's an opportunity to create value for your clients. So where are the bank accounts that your client has? Where are they held? What are the taxable investment accounts? What do those investments look like? What retirement accounts is your client a beneficiary of? Where are they located? What are the descriptions? What are the statements? Pension accruals, the right to receive a pension benefit. Do they own real estate? If so, where? Do they own it directly? Do they own it with somebody else? Do they own it through a foreign entity? Are they beneficiaries of trusts? If they are they those U.S. trusts? Are they foreign trusts? What type of trusts are they? Are they grantor trusts, non-grantor trusts? All of these questions make huge differences. And foreign businesses, which we didn't get into yet, have a lot of complexity in them, and a lot more complexity, unfortunately, since 2017, when the Tax Cuts and Jobs Act was passed, that added additional reporting requirements and very complex taxation rules that makes the reporting of foreign businesses a lot more complex and also a lot broader. Something as innocent as owning 3 rental properties in a foreign country can be considered a foreign business that has to report under a special type of form, that is Form 8858, that looks it looks quite a bit as a corporate tax return. And if you're a U.S. citizen, for example, that is self-employed in a foreign country, and you're exercising your business as self-employed, you're both your employee and your employer. That's the definition of self-employed. And as your employer of yourself, you are establishing a branch of yourself in the foreign country that might have also these additional requirements, report requirements, and that the IRS may assess a $10,000 failure to file penalty on the failure to file report your own personal branch in the foreign country. All these crazy results, they were already a lot of complexity, and as of 2018, the complexity has grown exponentially. And finally, earned entitlements from foreign government retirement programs is what we talked about and we refer to normally as foreign Social Security. With regards to business ownership, there are different levels of complexity, and the highest level of complexity, you typically see it when these international clients are U.S. shareholders of controlled foreign corporations. We're not going to get into the definition of that, but basically what you need to understand today is a controlled foreign corporation is a corporation that is controlled by U.S. persons, and those U.S. persons, in order to count, they need to own at least 10% of the corporation. So if enough of these U.S. shareholders control more than 50% of the shares or the vote of the company, this is a controlled foreign corporation where the most complex and more exhausting reporting rules apply, and very high penalties can result. But it's not limited just to control for corporations. Foreign corporations where US citizens have no control, but they are US shareholders, also have significant reporting requirements. And foreign partnerships, the fact that it's a partnership doesn't mean that the US is going to view it as a partnership. The US might view that partnership as a corporation. And so the foreign status of an entity doesn't determine what the US treatment would be of that entity. That is something else that can have requirements. And as I mentioned earlier, even something as simple as being your own employer in a foreign country because you're self-employed can result in complex reporting requirements and additional costs for the ongoing tax compliance.
Fantastic.
Next slide, please.
You know, Marina, we're running up against it, the clock here. It's 3 minutes before the hour's up. I know many advisors will have to be getting on to their next appointments. What I propose doing is we simply move these slides to the next session and continue that at that time, if that's okay with you. And of course, we won't be getting into what we have there, but I did just quickly want to cover off on a little bit about the GFP Institute and the masterclass that we have coming up. Here's some membership benefits that you can see here. The All Member Forum, where you're dealing with an educated, informed group of advisors working with international and cross-border clients. Monthly presentations on these very specific topics, of course. Find an advisor search tool, obviously targeted at the general population, looking for advisors that know about these international cross-border issues. A service provider database to locate those special service providers. Institutional foreign exchange pricing, of course, an exit tax calculator that we've developed in-house and in conjunction with CPAs and tax attorneys, as well as media inquiries. Here are the 3 primary benefits I would identify with the GFP Institute. Networking with a community of like-minded skilled professionals. I am thrilled to announce the first time I've said it, but we are planning a conference that'll be tentatively planned dates for end of February next year. So please stay tuned for that. Obviously, that'll provide a fantastic opportunity to network in person, reducing the workload to stay up to date on relevant topics. That can be very time consuming to stay up to date with how these issues change and evolve over time. Access to institutional level tools and resources that I just alluded to a moment ago.
And what about risk reduction? Something that we do, Ashley, is risk management. So, yeah. So I think risk management is an important benefit of joining the GFP Institute.
That's a really good point. And then about this masterclass on US inbound, outbound, international financial planning, what would you expect to take away from this course? I would say awareness of the major pitfalls and obstacles facing expat clients, understanding and having an appropriate investment banking and real estate options for your expat clients, how to manage risks with the appropriate insurance and foreign exchange, basic international tax planning on expat clients' income and assets, and knowing where and when to reach out for assistance, and obviously networking and finding and having access to these specialist providers. Another announcement that is yet to come to the existing GFP membership is the use of the GFP designation, and that is, as you can see down there, that will develop in the future when we're talking about specific cross-border designations. So in my case, that would include USA/Australia, or in Marina's case, USA/SUI, is that, or CH, or whatever the abbreviation.
It creates a lot of confusion with effort times, but yeah.
It's difficult enough with what 3 official languages in Switzerland. So the masterclass, we cover off on these 10 subjects that you see right here. We offer a proctored exam, a closed book proctored exam, before someone would be able to use that designation and be welcomed as a full member of the GFP Institute. Here are the guest lecturers that we have here, really a star-studded cast. We're talking some of the finest and most authoritative presenters in the business. Marina, don't blush when I say that. We've got Andrew Fisher here. Andrew Fisher, author of the Cross-Border Family Wealth Guide, talking about investments. Marina, you've obviously just had an introduction to her knowledge on cross-border tax. Alan Koski, talking about global health insurance. We heard from Jonathan Mintz just last week, an international estate planning attorney with significant experience, many published articles. Katrina Haynes, cross-border tax expert, former global mobility tax manager at Coke. So extremely knowledgeable. She received some fantastic feedback on her presentation this trimester. And Melvin Warshaw, one of my favorites, a incredibly experienced tax and estate planning attorney, who's also happens to be on the editorial board of Trust and Estates. So really an impressive group of presenters. Some more details here. So next class starts June 3rd, runs through August 13th. Again, 4 to 6 Eastern time, which is 1 to 3 Pacific time. That's because it's at an hour that is not ungodly early for me here in Australia. It's in a Zoom webinar format with slides available. Of course, each session is recorded if you're unavailable to make it live. Course fee is $2,995 for early bird pricing, and after April, that will change to $3,395. That fee includes the first year's full membership fee, and if we offer a $500 discount for referrals to the current class. So if that sounds like something of interest to you, then I would encourage you to go and check out this page that we have right here, and see if you would like to enroll in that. Let me just quickly go back to the presentation here, and we can finish things up with any questions. So I see already we have a couple Q&As. Does the GFP curriculum address the growing phenomena of digital nomads? It does inadvertently, Ryan, and good to see you here, Ryan. Digital nomads, I think it does actually. I think it's probably best suited for digital nomads because we're not going into specific cross-border cases in any great detail. So if you've got really an American moving abroad for a short period of time, this would be completely relevant to that. Are these slides available for download somewhere? They will be, Andrew. Thank you for joining. Scott, hi Scott. US citizen living in Japan, income is below the foreign earned income exclusion, so he cannot contribute to an IRA. Any alternatives to doing a taxable account? Well, Marina, what do you have to say about that? Wouldn't work anyway.
Any alternatives to doing a taxable account? No, you cannot contribute to an IRA if your income is excluded in the foreign earned income exclusion, but you can see whether revoking the foreign earned income exclusion and taking the foreign tax credit instead gives you a similar or the same result. That would allow you to contribute to an IRA.
Any other questions? Oh, here we are. Anonymous attendee has written in. Financial planning is a male-dominated field. Are most financial advisors for expats male? Are most expats male or female? Well, I think 51% of the population is female. Are most financial advisors for expats male? I think we've seen a pretty representative sample of attendees from the broader advisor community. I would call myself a loud and proud equalist. Have I specifically recruited women? No, but I am absolutely open to women's participation and strongly encourage it. So the long and short of what I was saying with that question is, we've seen about 80% male participation. In fact, now that I think about it, I think the industry at large is 90% male. So maybe that's a slight overrepresentation.
Yeah, that's what I was going to say. Yeah, certified financial planners have a higher representation of women, but I think it's 23%. But the industry overall is, I believe, is more than 90% male. So obviously, in the field, you're going to see that reflected. But I don't think it's particularly more male-dominated than the industry at large. And I would love to change the gender of the industry. So yes, if you are a woman and would like to get into international planning, please do so. It's a very, very thrilling profession. I would like more company. That'd be nice.
All right. Well, and there are a number, I should mention, there are a number of women in the current class. Some other
Yeah.
chats that have come through, yeah, 80% of the master class, that is, Matt's just written there. Yes, yep,
Hi,
okay.
everyone.
Hi. I think that's it. Any other final questions, concerns, or doubtful points that anyone has? Please let me know. And you can see there's our URL down the bottom, gfp.institute. And I look forward to seeing you all in 2 weeks' time. Thank you so much. And thank you, Marina. And we'll see you then. Have a wonderful rest of your day.